Welcome to the Appellate Division, First Department. We have approximately 6 hours of argument time requested, so I would ask that you ask for the time that you need, not the time that you desire. If we have more questions, we will keep asking them. We are familiar with the briefs and the records. That's all. People versus Townsend, appellant. That is submitted. Gordon versus State of New York, appellant.
Appellant, request 5 and 2.
Respondent? I'm sorry, did you say 5? 5, 2, and 5. ML Children is submitted. Rodriguez versus Manhattan Restoration, appellant. Respondent? 5, 1, and 2. 1232 Southern Boulevard versus FX Fowl, appellant. Respondent? 5, 2, and 5. People versus Rivera is submitted. Zurich American Insurance versus Giorgio Armani.
6 and 2, Your Honor. Respondent, 6, Your Honor. Respondent, Armani, 2, Your Honor.
Okay, 6, 2, 6, and 2. Chan versus Vilenchik, appellant. Is respondent here? Do you wish to submit? Okay, it's submitted. WGL Midstream versus Mead, appellant. Respondent?
5 minutes, Your Honor.
7, 1, and 5. People versus Sidhit is submitted. 333 Johnson versus Maple, appellant. Respondent? 7, 1, and 7. And again, if we have more questions, we'll keep asking. Forella versus 351, appellant. Respondent? 5, 2, and 6. West 81st. The next two cases have some overlapping issues, but since there's different plaintiff attorneys, I'll do them separately. West 81st Garage versus New York City Department of Buildings. Well, it looked like there were different plaintiffs' attorneys on each case. Is that incorrect?
Incorrect, Your Honor. I'm here on both cases.
Oh, okay, then I guess I just read it wrong. So why don't we argue them both together since they're the same legal issues? Okay. I'll give you both 5 and 2. People versus Washington. Respondent? I'm sorry, what? 4, 1, and 5. San and Infant versus New York City Housing Authority is submitted, and Chen versus 215 is submitted. So our first case is Gordon versus State of New York, and Justice Gonzalez is disqualified on that matter.
Good afternoon, Your Honors. James Ford for Hyacinth Gordon, the administrator for her son, Donovan Jackson. As I reviewed this, Your Honors, one of the more interesting things that I saw in the brief that was filed by the respondent, State of New York, was that they felt that they needed to ask for the very first time on appeal leave to amend their answer to include the affirmative defense of lack of capacity. And I truly believe that that's a tacit admission that they knew that under prevailing case law, CPLR 3211E and A3.
Why isn't it a substantive component of a claim the requirement that the administrator file a claim, rather than a limitation on the availability of remedies.
Even if it would be, they're required by 3211E to allege lack of capacity.
Well, if it's a substantive component, it would have to be present in order for the case to go forward, rather than a limitation. That would support the argument that it does not have to be asserted as a defense, that it's part of the affirmative claim to show that you have the capacity to go forward.
Well, they would either have to include it in the answer, or they would have to make a pre-answer motion to dismiss the case based on the fact of lack of capacity, which they did none of the above. They waited
I feel like
2.5
you
years.
didn't really answer my question. If it's a substantive component of the actual claim, why would it have to be asserted as a defense in the answer?
Well, I think I realize that the Court of Claims is, that the state of New York is arguing that based on the Court of Claims Act, that there's a distinction between someone being a fully authorized personal representative to file the claim. They don't have to be to file the notice of intention, but according to the Court of Claims Act, there is a distinction there, where they're basically saying that they have to be a personal representative with letters of administration in order to file the actual claim itself. I do understand that, but it does create a conflict. It creates an inherent conflict, because the concept of lack of capacity in a regular state court action under 3211A3, which is read in conjunction.
But isn't that the issue? We can't look at a regular state court action. We really have to look at the Court of Claims Act. And isn't it a condition, as my colleague is saying, to bringing the claim that there is capacity, that the proper letters have been obtained, et cetera, et cetera?
That's one of the issues, Your Honor. Yes, I do understand that. And
I think
also,
that's the central issue before us on this appeal, whether or not this claim can go forward where there wasn't a duly appointed administrator.
well, yes, Your Honor, that is
Do you
true.
want to address the 205 issue?
Yes, the 205 issue, I think, is probably even clearer, because I don't think there's really any dispute that CPLR 205A has been held to apply to the state of New York in Court of Claims actions. So that at bare minimum, and again, based upon the unique facts of this case, where the woman did have letters of administration. They were limited, but she did have letters of administration, and everything was going on during the pandemic. And during that process, she did eventually ask to have those letters, restrictions lifted from those letters, which she did.
But she commenced this action under those restrictions. And so do we have a properly commenced predicate action for 205A purposes?
Well, yes, I mean, it's from the claimant's point of view, yes, the action was commenced. There may have been
But if there's no capacity, was it properly commenced or timely commenced? I mean, it wasn't a nullity, I guess, is what I'm trying to get at.
It was no. The action was not a nullity. I mean, she timely commenced the action under the letters of administration that she had, and the
Right, but
actual.
the question is whether she had the authority to file it at the time she did, since her letters were extremely limited.
The letters were limited, Your Honor, but also during the course of the action, she did, under the exact same index number and proceeding in surrogate's court, have the restrictions lifted from those letters. So at bare minimum, she was acting under the color of law. She was the only existing fiduciary for her son's estate at that point in time.
Is there any tension between your position and the Court of Appeals decision in Liechtenstein?
No, not at all, because in Liechtenstein, in that particular case, Your Honor, that woman never had letters of administration and never commenced the action, even to correct it after she was granted letters of administration.
Thank you. You'll have time on rebuttal.
Thank you.
May it please the court, Stephen Yanni for the respondent.
Can you address your adversary's at least attempt to distinguish the Court of Appeals case?
Well, Liechtenstein is directly on point here. The factual circumstances are quite similar. In both here and in Liechtenstein, the claimant brought the action before receiving the proper letters of administration. And although the claimant later received proper letters of administration, even in Liechtenstein, she never sought to file and serve a new claim with those letters in hand. And the Court of Appeals held that the claimant didn't commence the action in accordance with the requirements of the Court of Claims Act. And also in Liechtenstein, the Court of Appeals declined to provide relief under CPLR 205A.
What's the response that you needed to assert that as an affirmative defense in order to raise it?
We have a couple of responses to that, Your Honor. First, the capacity question is a jurisdictional prerequisite in the Court of Claims Act, so it can't be waived. And we know that the requirement's jurisdictional from Liechtenstein, which held that the Court of Claims Act Section 2 and 3 contemplate that an executor or administrator be formally appointed before commencing an action against the state. And the only defenses that can be waived under Section 11C of the Court of Claims Act are timeliness defenses or service defenses. It doesn't mention capacity-related defenses. So for that reason, the legislature didn't express any intent to include that capacity-related requirement within this set of waivable defenses. And alternatively, as Your Honor noted, capacity is not simply a procedural hurdle for wrongful death cases, but it's actually a substantive element of a wrongful death claim. So the claim doesn't arise until an administrator has been appointed. And this court held in the Boffey case that a defendant doesn't need to separately plead lack of capacity as an affirmative defense so long as the answer denies the allegation in the complaint that the administrator has been appointed. And here, the state denied knowledge or information sufficient to form belief on that as to that allegation, and under the CPLR, that's treated as a denial. So for those reasons, the defense wasn't waived, and under Liechtenstein and as this court explained in Patel versus Desai, under these circumstances where the claimant doesn't have letters of administration, the action is not properly commenced under CPLR 205A, and there's no predicate timely commenced action for that toll to apply. So for all these reasons, we ask the court to affirm.
Thank you.
Your Honor, just briefly, with regard to the Court of Claims Act 11C that Mr. Yanni raised, I think that also guides the court. The Court of Claims in 1990 decided that they were going to amend their own Court of Claims Act to provide that there were jurisdictional grounds which could be waived by the state of New York if they're not raised with specificity in their answer. And oddly enough, what the respondent has attempted to do, the state of New York also, is they kind of switched gears and decided that they were going to say that, well, maybe it wasn't lack of capacity that we were raising, but we're raising that it's not timely because she wasn't authorized to start the action. So they tried to shoehorn it into a timeliness objection to try to get over the hurdle of the fact that they should have raised this either as an affirmative defense or they should have made a pre-answer motion. And timeliness, as we know from Court of Claims Act 11C, is one of the things that can be waived. That's jurisdictional. So there's no real authority for holding that lack of capacity is something that is absolutely sacrosanct, that they never have to raise it at any point before 2.5 years when they move to dismiss the case.
How would they even have had knowledge about that, about the lack of capacity? Because your client made a representation that she was a duly appointed administrator.
Yes, through
How would they have known? You're saying there's a waiver. Even if waiver did exist, how would they have known to assert it?
through discovery.
Well, but isn't that what they did? Through discovery, go ahead.
They did, Your Honor, but there's nothing, when they see an action come in from someone who lists themselves as the administrator of the estate, if I were drafting the pleading as a defendant, I would have included the defense pending further discovery, which they didn't do. They never raised it until they made a motion.
Thank you very much.
Thank you, Your Honor.
Rodriguez versus Manhattan.
Good afternoon, Your Honors. Sorry. Good afternoon, Your Honors. Kenneth Gorman for the plaintiff appellant. The trial court's order was fundamentally wrong because it disregarded the plaintiff's affidavit, the plaintiff's testimony, and the affidavit of Russell Rogers, which established that Manhattan Restoration had prior notice of the assailant's aggressive behavior. The plaintiff complained to Thomas Fitzgerald.
Counsel, I'm not hearing you clearly. Could you adjust the microphone?
I'm
in
sorry.
some
Could you
way?
hear me better now?
Okay.
Okay.
Loud.
He complained to Thomas Fitzgerald, he complained to Shai Stutnick, and he complained to Gavin Fries about the assailant's aggressive behavior. I mean, Shai Stutnick testified that he also had prior notice of the assailant's aggressive behavior at page 333 of the record before counsel inappropriately directed him not to testify about that. But even though he tried to whitewash his testimony after he came back, it still raises an issue of fact as to whether he has notice of the Johnny's aggressive behavior.
What about the fact that this defendant was not the employer of the alleged attacker?
On pages 20 to 21 of our brief, we cite the pattern jury the commentary to the pattern and jury instructions, which state that the rules and exceptions governing vicarious liability of a hirer of an independent contractor apply equally to a general contractor who hires a subcontractor.
Counsel, let me draw your attention to the affidavit filed by Mr. Russell Rogers, who's Manhattan's work supervisor.
Yes.
So here at Record 512, paragraph 16, he said that prior to this day, I have been at other job sites where Johnny has also worked for TMF Construction. Paragraph 17, I have witnessed Johnny on prior occasions get into arguments with other workers, displaying very aggressive behavior and getting in someone's face. Now, we know that this is, that Manhattan's motion for summary judgment was granted. My question is there any place in the record that provides more detail with respect to prior situations where this aggressor was involved, this alleged aggressor was involved, and Manhattan was also present? So in other words, is there a situation where Manhattan was the general contractor? Because I looked, and even if you look at the plaintiff's deposition, he talks about having worked with Johnny, quote unquote, for 8 months and at other sites, but there's no information.
Russell Rogers, I believe, worked for Manhattan. He was, correct me if I'm wrong, but I thought that Russell Rogers was a representative or a supervisor for Manhattan. But even if that was the case, if they had prior notice, if Shai Stutnick had prior notice.
Well, that's what I'm trying to figure out, prior notice.
Prior notice. We don't have anything else other than that in the record. There's nothing else.
Was Mr. Rogers deposed?
No, he wasn't. We just have his
It
affidavit.
was only an affidavit, right?
Correct.
And were there any questions asked of Mr. Rodriguez, the plaintiff, with respect to prior complaints about Johnny?
Yeah, at pages 154 to 155 and pages 271 to
There's
2...
no dates
He doesn't give dates.
or locations, so that we don't know when he talks about prior complaints if it was at that construction site where Manhattan was present or other construction sites where Manhattan was or was not present.
True. But at pages 271 to 272, he testified that he informed Shai Stutnick, Manhattan's owner, of Johnny's aggressive behavior in front of 3 other workers, and he identifies these 3 other workers by their first names.
Does a GC have a duty to keep work premises safe where it only has general supervisory authority over the work site as opposed to, say, an owner?
Well, it has an obligation to keep the work site safe, if it has prior notice of a worker's aggressive tendency and has an
I
obligation.
can understand with respect to its own workers, but with respect to another worker, though where have you established that in fact Manhattan's principal had notice of Johnny's aggressive behavior? In the deposition testimony, there's some references to it saying I said it, but nothing really specific, correct?
We got into his lawyer directed him not to answer any questions about Fernando Luna, the person who told him about Johnny's aggressive behavior. When he came back, although he tried to downplay it, he still had notice of an incident.
Thank you.
Thank you.
Time of rebuttal.
May it please the court, Edward Tobin, Gallo Bertucci Clark LLP for the respondent. Again, it's undisputed in this record that that Manhattan was not the assailant's employer. Therefore, Manhattan Restoration had no duty to the plaintiff with respect to this particular incident. In addition, the record just.
Duty owed in the absence of being the employer? Is there any duty owed in the absence of being the employer?
It is respondent's position that with limited supervisory authority over the site, there was no duty here. And again,
So in other words, assuming for argument that in fact Manhattan's principal was on notice of Johnny's vicious propensities, would that be sufficient to find a duty?
It's Manhattan's. It's respondent's position that would not, given in the limited supervisory and authority that Manhattan had in this particular site, and I believe that it's case law on that subject, and it's all cited in our brief. Respondent's superiority does not apply here, and with respect to the plaintiff's supposed expert affidavit, that was rejected by the lower court. Failure to have a site safety inspector on the site when this incident was unforeseeable, having a site safety inspector could not, as a practical matter and as a matter of law, prevented the incident from occurring.
Thank you.
Thank you very much.
With regard to the plaintiff's expert, the trial court abdicated its responsibilities in violation of CPLR 4511 by refusing to consider it because it couldn't find the local law that the expert relied on, rules of the City of New York 3301-02. That requires a safety supervisor to be on site, and the plaintiff's expert stated in his affidavit that industry practice required this, and that had a supervisor been on site, a safety supervisor been on site, he would have been able to diffuse the situation, which initially lasted 2 to 3 minutes. Thank you.
Thank you. 1232 Southern Boulevard versus XF Fallow.
Good afternoon, Your Honors. Kevin Scully of Quinn McCabe LLP for the defendant appellant FX Collaborative Architects LLP. In sum, the issue here is relatively simple. The trial court incorrectly held that respondent, the plaintiff in the underlying case, raised an issue of fact with respect to the applicability of the continuous representation doctrine, which would toll the statute of limitations.
Well, what should we make of the email correspondence relating to the water infiltration between July 2019 and April 2020? It seems to me that your client was involved in maybe coordinating what was going on, et cetera, et cetera. Isn't that sufficient for the purposes of this motion to let the case go forward?
I think the case law in New York is clear that just purely ministerial communications, which I would argue all of these emails and phone calls between the parties were what happened during that time period.
I'm sorry, go ahead, go ahead, go ahead. No, no.
Don't those emails actually provide at least some evidence or some issues of fact as to what exactly the extent of the participation of your client was in remedying these issues of the water infiltration?
I would respectfully disagree because despite all of the information in the opposition brief and in the opposition papers to the motion itself, there's not actually any description of the specific work performed by my client.
Well, did your client, for example, coordinate and participate in conferences with plaintiff and other entities regarding the flooding?
Well, there was a reference to a site visit in their papers. That was,
Just answer my question.
there was communication and there was a
Well,
site.
no, not much, obviously there's email communication. I'm saying, did they do more than that? Were they coordinating, participating in conferences, that kind of stuff?
They certainly were not coordinating anything.
But wasn't a written report actually provided to them summarizing the findings regarding the?
It was incorrectly emailed to them. It should have been emailed to the respondent, but my client never.
Well, couldn't it have been emailed to them because they were actually involved in seeking this advice in the first instance, that they were the ones who first contacted
They were,
for a report?
respectfully, that communication is really just referring respondent to the engineer that they wanted to.
Well,
work with in
well, let's
terms-
just step back to, who engaged the consulting engineering firm?
So in the record, if you see, there's a proposal from DeSimone, the engineer in question, to respondent.
Initially, who is the entity that engaged the consulting engineering firm? Was it your client?
My client had engaged them as a sub-consultant during the
So-
performance of the
so-
project.
So they are involved in some respect, correct?
They had been previously involved in a different specific matter in terms of, quite a limited aspect in terms of the project. They came on late in the project.
Why isn't this enough, though? This was a motion to dismiss. Why isn't this enough to at least allow discovery to go forward on the issue of continuous representation and whether the statute of limitations was extended?
Well, I think-
Based on that involvement.
I think because that would, for policy reasons, almost destroy the statute of limitations, where if you could just conclusively claim that the continuous representation continued to
But
exist
isn't
without
there
any.
actually some of the evidence that my colleague just discussed that substantiates that it's more than just a conclusory representation, and it's something that should be explored further in discovery, that there really isn't, may potentially be an issue as to continuous representation?
Well, I think one point to remember is that the court, in laying out the standard, focuses on the reliance, and the reliance is entirely within respondent's control.
Counsel, I'm looking at something different, which is New York City School Construction Authority versus Enid, 2017 case, where it says that the doctrine of continuous representation applies where an architect attempts to remedy a faulty design. So the remedial process in which an architect would engage does extend the statute of limitations. Why is this case different?
Respectfully, there's simply no evidence in the record that my client performed any remedial work in terms of the design or changing the design.
So for you, the conferences, the communication, the site visit, the report that was sent to your client but not to the plaintiff, those should be ignored?
I think there's a requirement that the respondent show specificity with respect to the work and how they relied on that work. What actions did they take based on my client's work? What actions did they not take? How did that stop them from discovering the alleged malpractice they're claiming?
Thank you. You have time. Oh, I'm sorry. Did you
No,
want
I
to?
just want one question, if I may. Thank you. You mentioned reliance, and I'm so glad you used that word, because it seems to me, when we're looking at the plaintiff submissions, there were allegations that they repeatedly, contacted your client for advice and strategy. And we can just talk about April 2020, that your client had responded to plaintiff's email regarding the second flooding, and you coordinated a conference call among the parties. And, the communication dealt with the flooding repeatedly. They were seeking your advice about how to proceed in you advise them.
Respectfully, I don't think respondent has laid out any specific advice that was provided and that they relied on. There were some communications, but I think the case law is pretty clear that communications alone are insufficient.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Daniel Horner for the respondent, 1232 Southern Boulevard. As your questions have indicated, this is a pleading motion. The facts as averred in
Want to
opposition.
address your colleague's point that you haven't shown reliance?
We most certainly have shown reliance. We
tell me
first
about it.
went to the appellant for their assistance in determining the cause and the remediation for this design defect. And then I think most illustrative of the reliance is that after they provided their report, their recommendations as how to address it, and the issue occurred again in April 2020, the respondent went back to the appellant and only to the appellant and asked again, we need a comprehensive investigation, response, how to resolve this and prevent it from happening yet a third time. So there was absolutely reliance. This is the architect of record. This is the design professional who coordinated the construction of the entire project. Every plan, every document that goes into the construction of the building, they were preparing and were using various sub-consultants to assist in the preparation of that design. But in terms of reliance, the respondent was going to the appellant because that was who they had contractual privity with. In terms of some of the appellant's other arguments that the services or that the allegations of a continuing representation were conclusory, it certainly was not. You have several instances of site visits, email correspondence back and forth, a report that was prepared by the appellant's sub-consultant who contractually the appellant was responsible for their work product. The sub-consultant's work product is that of the appellant's.
By the way, who paid for the consulting engineers ultimately? Was it you or?
There's no evidence in the record. As far as I'm aware,
point.
the respondent has
Okay,
not
fair enough.
paid for that. And the proposal, the origin of that is also very questionable. The proposal itself that the appellant argues is proof that the respondent hired the sub-consultant. That proposal, that there's no correspondence as to where it came from, no clear request from the respondent for that proposal. And the first paragraph of that proposal itself states that the sub-consultant was contacted by the appellant to perform investigation on the appellant's behalf, which further suggests that this was the appellant who was responsible for these continuing services, again, which the respondent relied upon.
Thank you.
Thank you.
So is that correct that your client, at least initially, reached out to the consulting engineer?
There were initial communications between my client and D.
Who
Simone.
reached out? Was it the plaintiff or was it your client?
I believe it was at the time of the flooding. I don't want to speak too on point on the exact specifics, but it was.
Your adversary just said that it was your client that did it. Are you pushing back on that or not?
I'm pushing back in the sense that my client was reaching out on behalf of respondent. They didn't actually do any substantive work. With respect to the respondent's claims
So
that
retaining a consultant, coordinating, and participating in conferences is not substantive work?
well, I certainly dispute that my client retained D. Simone. Certainly the proposal was sent directly from D. Simone to respondent. My client referred them to that engineer, but they never actually retained them. They never performed any work on behalf of my client. And I do want to point out one thing with respect to the architect of record. This is not a medical malpractice situation where there might be an ongoing relationship with a doctor for years and years. This is a specific project, and that project ended in February of 2018 with respect to my client's obligations. To the extent that respondent is claiming that somehow any subconsultants who worked on that project would work under my client's authority in perpetuity, that's just simply not the case.
Wouldn't that be something that discovery would better flesh out, as opposed to us sort of making that conclusion at this stage of the game?
I think discovery would be good at fleshing out actual factual disputes if they made specific allegations about the work performed.
Who retained the consulting engineers? Who paid for the consulting engineers?
Well, respectfully, I believe that's a respondent's burden to make out a case that they actually relied on that with specificity.
Well, this is a motion to dismiss, though, but thank you.
Thank you.
Zurich American Insurance?
Good afternoon, Your Honors. May it please the Court. Andrew Margulies from Ropers and Jeske for Zurich. I think one of the things that we have to look at here is the lower court in finding that these cases were not related to each other. The wrongful acts were not related. The first mistake they made was not enforcing part of the provision that says all claims which arise out of the same wrongful act or interrelated wrongful acts. And here they went straight into the interrelated wrongful acts analysis. And I think before we even reach that, we can conclude, without even getting to the interrelated wrongful acts, that these cases allege some of the same wrongful acts.
So the lower court seems to have focused more on the victims, the personal harm that flows to them, which argue or maybe was different. Is that the correct focus, or should the focus be on the plaintiffs complaining about Herrera's conduct to GAC?
They should be focused on the alleged wrongful acts by the defendants, which was GAC, who was one of the defendants. And I think the problem with the lower court in looking at that, the victims, they were doing it based on analysis of occurrence-based general liability policies. And so within the insuring agreement, and in Roman Catholic Diocese, one of the cases the trial court relied on, it was a CGL policy. And the very insuring agreement there says, this policy covers bodily injury caused by an occurrence. So there's a causal connection right in the insuring agreement that leads you down the path of proving the causal connection between the injury and the act. That's not the analysis under a claims-made policy. We're looking at the acts. Are the acts related? And here, in the Christing case, which was the case filed during the Zurich policy period, it was specifically alleged that GAC is liable for the negligent hiring, promotion, retention, and supervision of defendant Herrera. And in the Loretto Hayes case, one of the cases filed during the Hiscox policy.
Yeah. So are the acts between those two cases, Loretto Hayes and the Christian cases, is there a common nexus of fact between those two cases?
I believe there is, because the Loretto Hayes case specifically has that same allegation, that GAC is liable for the negligent promotion, retention, and supervision of Mr. Herrera. All these cases allege that there was one employee who was harassing female employees, and from GAC's standpoint, they received complaints, they knew that he was doing this, and they took no action to stop it.
And in fact, they promoted him instead.
They promoted him, and not only did they promote him, it was so bad that some of these employees said, transfer him from the store I'm working at to another store in the same outlet, and they transferred him. And one of the earlier cases...
That's where the subsequent acts occurred, at the subsequent store.
Exactly, and one of the plaintiffs in one of the earlier cases specifically said that she told Armani that if you transfer him, this same conduct's going to happen. And that's exactly what happened, the same conduct.
Is that your causal connection, that it was the transfer that caused?
I believe no causal connection is required, but I believe there was a causal connection, because their transferring him to the other store caused those later incidents. So while under the policy language, I don't believe a causal connection is required.
What do you think is required under the policy then?
Excuse me?
What exactly do you think is required under the policy to satisfy it?
Sure, there's two parts to the definition. It is the acts have to be related by, have a common nexus of any fact, circumstance, situation, or a series of causally connected.
Any fact is there in action.
Correct. So I think that it's enough to have a common nexus of any fact, circumstance, situation. And here, the fact is, all these women allege that they complained to Armani about it. Armani did nothing, and he continued to harass these women. They even transferred him to another store, and it continued. I think that is, and this all happened in a very discrete time period, in a very discrete location. This is not a situation where you had incidents going 20 years like you see in some of the cases. This was a 2-year period, the same employee, the same manager supervising him, and the same conduct. So we submit.
Counsels, so Armani seeks to differentiate the 3 claims that are an issue, right? And says that with respect to the first one, Oberlock, that had to do with race and race and gender discrimination, but nothing to do with sexual harassment. And that was separate and apart from the second claim, which involved the rape charge, right? And those were covered by Hiscox. But then they say the third claim, which involves the 5 women at the transfer location, that's totally different. How would you describe the distinctions or the commonalities?
Sure. One of the cases had to do with race and harassing based on race. The second case that was still in the Hiscox period was sexual harassment and sexual abuse, as was the third case. But I think as the 10th Circuit said in applying New York law in the Bressick case, they said they chastised the district court for focusing on the differences between the cases, not the similarities. They don't have to be identical. They just have to have a common nexus of fact. And the fact that you are aware that you have an employee who is harassing people, whether it's because of their race or because of their sex or something else, and you take no action to stop that, I don't think you focus on the differences between those. I think you look at the similarity. You have an employee who you know is committing harassing conduct against women.
And with respect to the first claim, the Oberlock, did that reference sexual harassment in any way?
It did. In part of that case, one of the allegations was that Ms. Oberlo alleged that she told Armani that other women were being sexually harassed, and they retaliated against her because of that.
And her relationship to those women was that of supervisor, right?
Correct. And they were all working in the same locations, and she complained about that, and she claims that she was retaliated against for bringing those complaints to GAC's attention.
Thank you very much.
Thank you, Your Honor.
Good afternoon, Your Honors. Leonard S. Zurich of Zurich and Controños for Hiscox Insurance Company. So,
Counsel, why aren't these connected acts? I mean, especially, particularly the second and the third one, putting the first one aside for the moment. Why aren't
by
those?
the first one, are you referring to Oberlaw?
Yes.
So Carmen Loretta Hayes had a dual employment. She worked part-time as a sales associate, and she worked as an employee of a janitorial service.
Why are we focusing on the women as opposed to not focusing on what occurred here? Is that the women assert that they were sexually harassed and that it was reported to GAC, and GAC failed to remedy the situation with respect to Herrera, and as was pointed out earlier, in fact, promoted him or moved him to another location where the same behavior continued. Shouldn't we be focusing on those common nexus or nuclear facts?
Well, if you focus on the failure of the company, virtually any employment claim is going to have an allegation that the company knew or should have known and failed to do something about it.
This is the same person doing the acts, the same employee doing the acts, and women continuing to complain about the same employee doing the acts and the company not taking action. So it seems like there are a lot of similarities between the second and third claims in this case. It's not like most claims. They're much more similar than most claims.
Let me point out some...
Especially because it's the same harasser.
Let me point out some key differences because it's really not the same harassment. So the first claim, the Carmen Loretta Hayes, she's the janitorial person.
It's the second claim.
You're referring to that as the second claim? Okay, I'm sorry. Oberlaw is the first claim. Oberlaw is his supervisor. She accuses him of stealing jewelry. He calls her the N-word. He shoves her. She was the only plaintiff who was terminated. She's got Equal Pay Act claims. Her claim is totally different, and she doesn't claim any sexual harassment herself.
But she was the supervisor who advised GAC that there was a problem with respect to Herrera, right?
Correct, but that's not part of her claim.
And said it was sexual harassment.
That's not part of her claim. She's claiming that...
But it's not, the issue is not claims. It's a common nexus or nucleus of facts.
Correct.
And aren't you hearing from us that it appears that there is a common nucleus of facts, and it's the complaints and the failure of the employer then to act with this particular harasser?
I hear that and I understand the concern. My response is that if you are going to aggregate claims because of a failure of the company, even when it's the same actor who's doing it, you're going to put a lot of claims back in this year. Let me give you an example.
Okay, well, maybe we'll try this a different way. How then would you define common nexus or nucleus of facts? What meaning should we give to that phrase?
A causation, a causal link between the act of
But that's misreading the policy because it's in the disjunctive. There's an or. It says a common causal connection or cause the same or related damages or a common nexus or nucleus of fact.
Right, and the trial judge ruled that under New York law, a common nexus was the functional equivalent of a causal relationship. So that common nexus has to be between the act of Forella and the ultimate harm to the plaintiff. And they are completely different in all three cases.
But we're repeating ourselves, but the same thing runs through all three, which is that complaints kept being made about this particular employee and trouble with this particular employee, and the company kept not taking any action with respect to this particular employee, and this particular employee is alleged to have kept performing bad acts, which is what resulted in all three claims. So that seems like a lot of commonality between those three claims, all in a very short time period. This isn't a 20-year time period where things were happening.
It's a little longer than 2 years.
Finally, he was terminated by the company, but it was the company's not terminating him and continuing to employ him despite all these complaints that led to 1, 2, 3 claims.
Well, I just disagree that that is the correct test for an employment practices related claim. There is no case in New York which holds that the inaction of the company is the link or connection for these interrelated.
Again, you keep suggesting that there has to be a causation, a link, and I'm suggesting to you that the language in the policy is much broader than you're interpreting it.
Well, the language is a common nexus. There needs to be wrongful acts that have a common nexus or the causation, correct? And it's the common nexus that is lacking here.
But the common nexus is the same employee. The complaints are made to the employer and nothing is done. Now, maybe you would be in a stronger position if it was Herrera and a couple other people engaging in sexual harassment, but you have the same person.
But so I think it's important to bear in mind the Loretta Hayes, that was a sexual assault. It was a criminal sexual assault. She called the police.
Are you saying that they have to be identical, that each claim has to be identical for it to come under the...
No, what I'm saying is that the wrongful acts have to give rise to the claim. So the wrongful act of sexually assaulting the woman in the lunchroom while she was cleaning it didn't give rise to the Kristen claim or to the Carol Oberlauf claim.
Thank you very much.
Good afternoon, Your Honors. Ryan Cummings on behalf of Giorgio Armani.
Your position that you don't care which one of them is found responsible as long as one of them, we're definitely going to find one of them responsible. So do you really care which one it is?
I don't care. I just want to point out that there's no daylight between these two policies. It's one of them. That's our position.
We agree with you completely.
Okay, thank you.
It's one of them. It's one of the two.
They get it too.
Thank you, and excuse me. Just briefly, the counsel mentioned that the lower court found that common nexus means a causal connection. But again, I assert that the lower court did that based on a faulty analysis, starting with analysis that's based on an occurrence-based CGL policy, where the insuring agreement specifically requires a causal connection. Bodily injury caused by an occurrence, which makes you look at the victims, look at the injury, and see whether there was a causal connection between that. And that case involved conduct over a period of time, over 6 years, different locations, and they found that, did the assault in year 1 cause the same injury as the assault in year 2? And they didn't. So this is different. We're looking at the acts here. And the acts, as Your Honors have pointed out, there is a common nexus. And it doesn't matter whether there are distinctions between them. One of them was sexually assaulted. One of them was sexually harassed. You have one employee who was harassing women. Armani knew about it. They complained to it. They did nothing. They promoted him. They transferred him. That led to further. So we think that is a sufficient nexus.
What do you think is the closest case from around the country? I mean, there's not much case law on this. What is the closest, you say, to our fact pattern?
I think the Bresic and Young case out of the 10th Circuit, which applied New York law, where you had them specifically saying, don't look at the differences, look at the similarities, and apply the policy language. And where the policy language, and it was almost identical policy language, any common nexus, any common fact, circumstance, situation. That's all you need, any, not all, just any. And here there are certainly any common facts.
Thank you.
Thank you, Your Honors.
WGL Midstream versus Mead. Go ahead.
Good afternoon, Your Honors. Tom Cadera of Oric Harrington on behalf of what the parties generally refer to as the sellers, who are the appellants and cross-respondents today. This dispute is over who is entitled to $22 million that was placed in escrow by sellers to be used as the source of indemnification if and to the extent Mead, the buyer, incurred a loss arising from a claim, cause of action, or right to payment asserted against it within 2 years of the sale in connection with a contract running between the pipeline's builder, Transco, and one of its subcontractors, Welded Construction, which contract was the subject of litigation at that time. The undisputed facts show not only that no such loss was incurred, no such claim was asserted within those 2 years, but that even now, more than 5 years after the sale took place, and 3 years after seller's indemnification obligation expired, Mead still has not suffered an indemnifiable loss.
Has that claim ever been resolved as of this date? Is that still an ongoing dispute?
That's correct. The litigation remains ongoing at this time. It has not been resolved either by way of litigation itself or settlement.
And what would have been the basis to demand the entire, the record is a little confusing. Sometimes it's 21 million, sometimes it's 22 million, but whatever the amount, what would be the basis to make that demand here that the other side would be entitled to that money at this point?
Yeah, so the other side, in theory, could be entitled to that amount of money if, within that 2-year period, a claim had been asserted against it, demand for that amount had been asserted by Transco in connection with a loss, whether judgment or settlement, related to the Welded contract. But because the Welded litigation did not resolve in either judgment or settlement during that time, Transco never made a claim or asserted a demand for payment.
So there's a statement in the November 11th letter, and maybe it's a notice, but at least it's a letter. Buyer has resolved the Welded claims by obligating itself to pay the outstanding Welded indemnity escrow amount in exchange for complete resolution. Is that factually a correct statement?
No, it's not. And the reason it's not is if you look at the actual terms of the settlement agreement, all it purports to do is resolve what it refers to as a possible liability that Mead may be payable at some point in the future. And per its terms, it terminates, as it did here, if Mead isn't able to get the money out of the escrow account. And so as a consequence, they didn't actually obligate themselves to pay anything. All they did was set up a mechanism by which they could try to get that money out of escrow, pass it to Transco, and then get for itself a release from any claims.
Did they ever actually ask for your consent to a settlement?
No. I think Your Honors have seen the two documents they point to. Those documents make no request whatsoever of my client. They don't reference the word consent. they are most critically provided after the agreement's already been signed. It's purported to call it a claim notice, but the claim notice comes after they've already executed the settlement agreement. So no opportunity to defend has arisen at that point, and certainly no opportunity to review the terms, opine on the terms, offer any sort of view is afforded by way of that.
So there's no way of knowing even now as to whether Mead owes Transco anything?
That's correct.
Right?
That's absolutely right. If Transco prevails in the underlying litigation or settles it for nothing, but obviously that's unlikely, but if they prevail in the underlying litigation, they would have zero injury, and in turn, Mead would have a pro rata obligation to pay nothing, because their obligation to Transco is only pro rata as to the losses that Transco incurs in connection with the welded litigation.
Did the settlement agreement provide details?
I'm sorry, which?
Proposed settlement provide details.
The proposed settlement agreement that ran between Transco and Mead, it purported to resolve a possible liability that might come to pass at some point in the future. But again, as you know, that wasn't provided to my client until litigation actually was commenced in this case. Kind of reiterating the point, the idea that Mead could unilaterally create its own indemnifiable loss by approaching Transco on the eve of the 2-year expiration and asking Transco to preemptively settle a possible liability is squarely at odds with the PSA, which limits Mead's indemnity rights to claims that are asserted against it. The reason why Mead can't show now that any claim was asserted is because of what we were just describing. That Transco itself, in turn, couldn't actually make a demand of Mead during that period of time, itself not having suffered any injury. I think it's important to note, this is a 2-year limitation period, or survival period, whatever you want to call it, sunset period for this indemnity that runs after a sale. After that time, that amount of money is supposed to release to the seller who put that money in there as part of its purchase price. The conditions that would have allowed that money to come out and be used for indemnity were not satisfied, and it's rather plain that as a consequence, that $2 million, or $21 million needs to then be released out of escrow to sellers in accordance with the PSA.
And counsel, if I may, the bottom line is that, your client didn't deny any claim. You merely asked for some information to determine whether or not the settlement would be reasonable. You wanted information, they didn't provide it.
That's absolutely right. And I think adding to that, it's also critical. We're talking then about the procedures around how settlement might result in an indemnifiable claim, and those procedures simply weren't followed. The claim notice was sent after the settlement agreement was signed, and so no right to defend was permitted, and no input, no review. The fact that we had to wait till the litigation to review the agreement is significant.
Thank you very much.
Thank you.
Good afternoon, Your Honors. Jeff Kramer from Loch Lord for Mead. The contract
Let me ask you the same question I started with opposing counsel. That case has never been settled yet, the welded litigation, still ongoing. So how could that obligation have accrued under the agreement where there's still no resolution of that lawsuit?
Because the welded claims as defined in the PSA does not mean the welded litigation. Mead's view of this case and the view of the contract is that welded claims, which is section 9.2A3 of the PSA, it's at 258 of the record, describes welded claims incredibly broadly. It is all...
Let me interrupt. Isn't the whole purpose of this obligation that the other side gets a chance to review the reasonableness of the settlement based on how the underlying claim is settled? And if the underlying claim is never settled, how can that occur?
Because the welded claim, as it's defined in the PSA, includes the liability and exposure that Mead had to Transco for Transco's liability to Welded. And
what is that exposure today?
that exposure is, well, the parties agreed in the PSA that it's $71 million.
What is the exposure? What is Mead's exposure today? Because Mead's counsel in his EBT says he doesn't know. It could be 21 million. It could be less.
Nobody knows.
The agreement's expired at this point.
Well, the Transco, so two questions. I'll answer the first one, which is the exposure could be higher than $21 million, and it could be zero.
But we don't know. That's the point. We have no idea what the exposure is, so we have no idea what the indemnity, what would have been a reasonable settlement.
Well, but the parties said what would be a reasonable settlement by putting it in the PSA. This
Let's
20
go to a more practical question.
Sure.
It definitely requires that you send them the settlement and request their consent, and they cannot unreasonably withhold that consent. How could the notice that you sent to them be construed as a request to consent to someone? There's no language whatsoever in that notice, hey, will you consent to this settlement?
So there are two notices here. There's the claim notice, which laid out every material term of the Transco settlement. And let's be honest, the Transco settlement between Transco and Mead was exceedingly simple. We will pay you this amount for a full release of liability. That's what's in there. And in fact, the sellers claim that
Did you request their consent to it?
And so then in the indemnification notice, which went to the escrow agent, we requested release of the escrowed funds
Right,
based
but
on the
that's not
settlement.
answering the question. The question is, did you ever request consent to this settlement?
That is the consent to settlement. It could only have been considered a request for consent to settlement because under the escrow agreement, the only way the escrow agent can release the funds to Mead is with seller's
I'm
consent.
sorry, the notice was sent to the escrow agent. You needed the consent of the sellers.
It was to the escrow agent and the sellers. So the sellers did receive it.
You're saying all you needed, the only right they had to exercise their right to reasonably consent after reviewing the terms of the settlement is a bold demand, give us the $21 million, which was the utmost amount under the agreement? And that was enough to trigger their obligation to not unreasonably withhold their consent?
Yeah, it's the only reasonable reading of those two notices put together. It's the only way Mead could have received the money from the escrow agent was with seller's consent. And the reasons that the sellers give now for why the settlement was unreasonable is not what they actually said when they refused to allow withdrawal of the escrow
Didn't they actually ask for more information? Wasn't their response not a no, we won't consent? Wasn't it, hey, can you give us a little more information about this?
They did, but that is pure pretext because the parties knew, they heavily negotiated the PSA. The sellers knew exactly the liability that was being settled here. It was the welded claims as defined. They knew where the $21 million came from because it's in the PSA. This is at record 634, schedule 4.6 of the PSA. The parties agreed to this amount. And they also knew,
They agreed to cover Mead's share of Transco's liability to Welded. So what was Transco's liability to Welded and what was Mead's share?
Transco's liability, what was Mead's share was 30%, right? That was its exposure to Transco.
What was Transco's liability to Welded?
The parties put in the contract that there was a $71 million claim from Welded. That was
If the litigation hasn't been resolved, how can you possibly know the answer?
because we had the exposure, and Mead and Transco settled for the amount the parties agreed would be Mead's the total amount of the Welded claim against Transco and Mead's percentage of that amount. That is the amount that we agreed to with Transco. Thank you.
you very much.
Just very briefly, that last point, that $71 million that was referenced and the 29.4% share of that comprises the amount of money that was taken out of escrow. So in effect, it was settled, the claim was nominally tried to have been settled for 100% of the asserted value in the complaint by the plaintiff in that case. So it assumes essentially that the plaintiff would succeed on the entirety of its claim in full to the dollar in the litigation. That's the value that was nominally settled as the good faith settlement.
Sir, do you agree with your friend that the sellers received a claim notice that satisfied section 9.3 of the PSA?
I do not agree with that. The claim notice came after the claim had already been settled. The claim notice should have been sent when a claim was asserted. And as I mentioned earlier, because no claim was asserted here, no demand for payment was made, because Transco had never incurred any liability or loss, as a result, they really couldn't have sent a compliant claim notice because the conditions hadn't been satisfied.
Thank you very much. 333 Johnson versus Maple.
Good afternoon. Between July 2018 and December 2018, Maple, the
Who do you
respondent.
represent and who are you?
I'm Therese Darty on behalf of the appellant. Thank you, Your Honor. Do you want to wait, not waste time? Between July and December of 2018, Maple, the respondent, repeatedly lied to the appellant. It concealed information about the value of the property, which was the asset that the company,
Counsel,
their
don't we
joint
have
venture
to
owned.
focus on the terms of the agreement itself to define what the obligation to disclose is?
Two things with that. There's certainly a fiduciary duty to disclose all of the facts relating to the
Well, you're
property
saying
when
there's
they
certainly,
ask.
but isn't that one of the central issues in this litigation, whether there is a fiduciary
yes.
duty under the circumstances?
Under Delaware law, there is a fiduciary duty unless and until it is waived in the LLC agreement. This
Well,
LLC agreement
isn't the rule that
expressly-
you look, isn't the rule that you look to the terms of the operating agreement, and it's those terms that set the parameters for what obligations are imposed on each side under the operating agreement, and that you can't impose a fiduciary duty which would contradict a clear limitation in the express terms of the agreement.
There is a common law fiduciary duty that exists unless and until the LLC agreement clearly eliminates it.
Well, that's a question. What does Delaware law require to eliminate it? That's the question before us. Why don't you address that?
It needs to have a excluding the fiduciary duty, which is irreconcilable. If you have
So is your position that it has to say there is no fiduciary duty, and unless it says explicitly there's no fiduciary duty, then there is a fiduciary duty?
If there's a duty set forth in the agreement that is irreconcilable with a common law fiduciary duty, then that is too.
So what about the obligation in the agreement, or the statement in the agreement, that the only obligation that the seller has to disclose under the agreement is the sales price that the initiator would accept? What other information is required under the express terms of the agreement?
Under Delaware law and in this LLC agreement, a common law fiduciary duty exists under Section 9 here. The 12.5 is a right of first offer, which was never triggered, it was never employed, and it can't be relied upon to excuse or override the fiduciary duty. The right of first offer.
Why is your position it wasn't employed?
Under Delaware law, the right of first offer and the specific language of this LLC agreement in 12.5 says that when there is, and I'll read specifically, there's a intent to sell when Maple member first has an intent to sell.
So counsel, can you answer that?
Yes, I can. If Maple member desires to cause a company sale, then Maple member shall first give to the other member notice and give an offer notice. That was never given here. It was never triggered whatsoever. There was never, under Delaware law, under the RCM case that we cite, when there's a first desire to sell, the first thing that has to be done with a right of first offer, this is not a right of first refusal, right of first offer, they have to go and give notice. That was not done here.
And are you saying that because it was a draft? Is that
no? I'm
what's the
saying
basis
that
of that argument that it wasn't
I'm
given?
saying that because they had an intent to sell, they hired a broker, they went and negotiated, they accepted 10 offers from the market, they negotiated an offer, accepted an offer from Steele. So they only came to Maple not to give them, when they had the first desire to sell and give them the first opportunity to make the first offer, they came and gave them the 11th after it was already done. The RCM case says it is not fulfilling your obligation for a right of first offer when you negotiate with the marketplace and then go back to the holder of the right of first offer to ask them to match. And that's what was done here. They did not seek to trigger anything under 12.5. They did not seek to give the plaintiff, the appellant, a right of first offer. They went and negotiated.
So under your reading of 12.5, Maple had to first go to your client and allow them to make it tender whatever the offer was that they put in the notice. They could not have any preliminary discussions or other discussions with potential buyers.
Under the law, they could test the market, but when they had a desire to sell and they knew the price that they wanted to get, their obligation is to go to the plaintiff. So if they
Why
were
didn't
going
that
to,
occur what's your position as to why that didn't occur in this case?
that occurred certainly when they hired the Pinnacle, the broker, in 2017.
Well,
when they-
wasn't, you just referred to testing the market. How could they know what they were willing to sell it for till they tested the market, found out what the market was, and had some sense of what they could really obtain
Here they
for the
had
property?
10 offers that they negotiated. The RCM case is directly on point. The RCM case says the right of first offer is not met where a holder is given the opportunity only to match a negotiated offer between the buyer and the seller. They were far too late, and the notice, there was no notice here whatsoever under 12.5.
I have a question about that. I just want to go back. So Section 12.5 just requires providing notice of the price. You agree with that?
If
No.
If they were seeking,
Just give me 1 second.
yes.
Let's take a step back because we're going to look at the language. So 12.5, and I have it here. We're just focusing on the price. Let's just agree with that. Okay. Now, so do I have it right? Because I'm just trying to figure this out. That they didn't have notice because it was a draft notice, I believe, to Mr. Lee. Is that it? That because it was just a draft? Is that what you're?
No. They had an obligation to, if they wanted to trigger the right of first offer, if they wanted to sell without the consent, they had to give a written notice. In the first instance, they first had to give the first opportunity to give an offer to the plaintiff. They did not do that.
I just want to follow
The
one question.
draft-
Okay, that draft. But the draft did contain the price, right? To me, that's a yes or no. It
It
contained
did contain the price, but it was far too late. By November 15, it's far too late to give the first notice to the member to trigger the right of first offer. They never sought to trigger the right of first offer. They never gave a notice and sat back and allowed them to discuss, allowed them to decide.
12.5
They asked him to waive it. And when they asked him to waive it, under the blue chip case, this court made very clear that when the managing member is negotiating a right and has a fiduciary obligation, it must disclose all of the facts. So in October, on October 26th, when they came,
Counsel, in 12.5, which pertain to the right of first offer, where does it say that all of the facts have to be disclosed other than the price? Because I'm looking at paragraph A, which offer notice shall set forth the cash price the initiator would be willing to accept in respect of such company sale, parentheses, the ROFO price.
okay, I'm talking about the fiduciary duty
No.
under
I'm
the common law.
Listen to me.
I heard your question.
Thank you.
I'm answering your
12.5,
question.
With respect to the agreement, where else does it say that additional material has to be supplied in the notice?
If an actual notice, which was sent pursuant to 12.5, that was timely sent to the correct
Let me
persons
stop you there on
and
timely.
sent
Is
pursuant.
there a time element in 12.5?
Absolutely, the word first is in there 3 times.
Sure.
That's what we're
Of course,
talking
but that
about.
doesn't mean that they can't test the marketplace and ascertain the price and then give you notice.
This is not testing the marketplace. This is 1 year of being out in the marketplace, talking to several different potential buyers, getting several offers and negotiating one all the way to the end. They didn't go and give a notice and allow the plaintiff to evaluate that and to see whether they wanted to buy. They asked them to waive it. They never sought to trigger the right of first offer under 12.5. If they had done that, they would have sent a proper notice and they would have laid back and done nothing. But here they had a deal in place and they asked them to waive it, and they pressured them into waiving it. Even Ms. Lee told them twice that there was no offer, there was no notice that was pursuant to 12.5 given there. And even the plaintiff admits in his deposition, Mr. Rubin admits that there was no offer given. There was no notice given under 12.5.
I'm sorry to interrupt you. So does it, Does your position rise and fall then on what meaning we give to the word first in 12.5?
Absolutely, it requires, if there is a sale, if there's a desire to sell, then Maple member was required to first give notice of that to the minority member.
You're saying that's the difference between a right of first offer and a right of first refusal? and that they
100%.
treated this
That's
as a
exactly
right of
correct.
first refusal and not as a right of first offer, and they weren't allowed to do that?
Exactly correct. And the
Because, I'm sorry,
RCM
your
case-
point, if I understand it, is that 12.5 simply wasn't triggered because they didn't comply with the requirement that your client get the first offer.
That's correct. That's correct. So
Okay, I think we have your
12.5 is
argument.
irrelevant, and we're back to blue chip, which is what this court made very clear, that when you're in the situation here, when you're asking for a waiver and you're negotiating that, you have a right to disclose all of the facts. And they certainly knew about Steele and Netflix, and it's certainly a material fact, and they had an obligation to disclose it, and they failed to.
Thank you.
Thank
You have
you.
time on rebuttal.
Good afternoon, Your Honors. Matt Parrott from Fried Frank for respondents, Maple member.
So
and
how, you heard your adversary, how in this instance was 12.5 the right of first offer triggered?
So, Your Honor, if you read 12.5, you'll see that it states that at any time after the venture is formed, Maple member may cause the sale of the property, and if it desires to do so, it shall first give to the other member notice thereof.
So let me stop you there. Your adversary says, presumably there's an issue of fact as to this, or argues as an issue of fact, that in fact you didn't do that. You went out, negotiated for a year, had a deal in place, and then you gave notice. So it wasn't first notice, it was 11th notice.
So I think it's important to step back and look at what the parties' respective obligations and rights and duties were under the operating agreement. So in this instance, Maple member was the managing member, and under section 9.1.
But let's just focus on 12.5 first. Let's just, because that seems to be the crux of the argument, that 12.5 wasn't triggered.
This argument assumes that the receipt of unsolicited requests or offers to...
Well, were they unsolicited, or did you go out and negotiate? Let's say, for example, you negotiated heavily, had a deal in place contingent on 12.5. Would you say, and under those circumstances, you still would have complied with 12.5?
You would comply with 12.5 if you found a deal that the managing member decided was a deal that was worth pursuing, and under section 9.1, the managing member was given the authority and the duty to manage the property, to deal with potential sales or transactions relating to the property. That's what they were doing throughout 2017 and 2018.
If we accept your version of how this right of first offer is triggered, what would in reality be the difference between a right of first offer and a right of first refusal? Because if this was a right of first refusal, the transaction would have played out exactly the same way. You didn't come to them till there was a concrete offer you were about to accept, which is what a right of first refusal is. So doesn't that, if we accept that this is a right of first offer, then aren't we swallowing the difference between a right of first offer and a right of first refusal?
I don't think so, Your Honor, because they were offering them the opportunity to buy the property at that price.
Yeah, but what then is the distinction between, if that had been a right of first refusal, wouldn't it played out in exactly the same fashion, that they would have offered to them at that price, which is what a right of first refusal is?
The difference, Your Honor, is if you look at section 9.1, they were charged with soliciting potential offers to purchase the property. And so they fulfilled that duty for the beginning in October of 2017.
Then what do we make of the fact that 12.5 isn't a right of first refusal? If we accept your interpretation, and that was the job of the managing member to go out and get offers and come to them once an offer was actually received that they were potentially interested in, why wasn't that described as a right of first refusal as opposed to a right of first offer, which sort of suggests that before we really enter into a serious process, we're going to figure out what the price is and offer it to you?
So what you see in the submissions around the offers that were made, the unreasonably low offers that were rejected and that that Maple member was entitled to reject in its capacity as the managing member under Section 9.1, is there was no offer that made it make sense to even discuss doing a sale of the property.
What does a right of first offer mean? If a right of first offer means that you just wait until there's an offer you're interested in, then again, it sounds like a right of first refusal. At what point in the process, before you ultimately have the offer that would become a right of first refusal, do you have an obligation to come to them first?
There was no ability for the client to find any valuation on this property that would have warranted them accepting the offer.
Is that your position? You couldn't get an appraisal? You couldn't go to a broker and get a value?
They did get a broker.
No, but you couldn't get an appraisal to get an appraised value of the property?
They got an opinion of value. I think it said it was.
So then why do you need to go and essentially negotiate a full deal and then offer it to them, as opposed to what your adversary is saying is it's the first offer?
Well, they didn't negotiate a full deal. They obtained a purchase price that they thought was acceptable, and then they went and they offered the ability to do the transaction to.
That's a right of first refusal.
And they refused to do that.
Counsel, I'd like to pivot slightly. So we know that under the Delaware Limited Liability Act, fiduciary duties can be expanded, restricted, or eliminated by provisions in an operating agreement, right? And your colleague here has referenced Blue Chip several times. Blue Chip is New York law, not Delaware law, and as we know, Delaware law is here applicable. Could you discuss Blue Chip in light of Compresa, which is the Court of Appeals decision, which pretty much limited Blue Chip to some extent? Also, could you address the issue of self-dealing, which I believe was an important issue in Blue Chip?
So what I would say to Your Honor is that in the Wilmington leasing case, the Delaware Chancery Court held that the court has to look to the terms of the LLC agreement in order to determine what the fiduciary duty is, and if a party complies with what's expressed in the parties' agreements, that means they've not breached their fiduciary duty, they've fulfilled it. Here what happened is they sent the 12.5 notice, which Ms. Doherty says wasn't a 12.5 notice. You heard her say it herself, and she was pretty adamant about that. After they sent that notice saying what the price was, the parties engaged in 5 weeks of negotiations about, well, what should we agree are the disclosure obligations in connection with this sale? And so they went back and forth, and after 5 weeks, appellant came up with representations that they wanted to add to the agreement in order for the sale to go through. Well, the parties agreed on that. They got every representation that they wanted. The only reason the sale happened was because they agreed to amend Section 12.5. There was no longer any of the requirements that you're talking about, this distinction between right of first offer or right of first refusal.
But is there a legal distinction between the two in your mind?
I don't think it matters here, because what happened is they rejected the offer notice, and then the parties engaged in a discussion about, do we want this sale transaction to go through? And they said, we'll agree to that. We don't want to buy the property for $52.5 million. We'll agree to that as long as you confirm you're not getting any undisclosed consideration, which we confirmed, and that was true. No proof after 4 years of discovery, depositions, all this nonsense about 888 Broadway, the Tabak lease for the 121 Morgan property, that used to be their theory.
So, sir, is your point that by virtue of your friend's clients waiving the right, that any breach of 12.5 is academic?
Well, yes, but also they say that that was never even triggered. That's not the relevant language to look at. What you have to look at is, what did the parties agree to after the price was disclosed? And they're very sophisticated people. They're represented by counsel. We negotiated for 5 weeks. We gave them every single representation that they asked for, and they're in the agreement. And so, of course, we should have, they've waived any right to argue that they should have gotten some other form of notice.
So I'm sorry, just one more question. On 12.5, 12.5, it seems to me the first question is, did Maple desire to sell? Because if it desired, quote unquote desired, then there were requirements that were imposed upon them by Maple by 12.5. How would we know when Maple desired to sell the company?
Maple member didn't desire to sell the company until they got a price from Steele after negotiation that
So
seemed
it's the
like a
first,
good
so you're
price for the property.
acknowledging it's not the right of first offer, it's the right of first refusal.
What I'm saying is that
And that concerns me, given the language of 12.5.
what I'm saying is that the parties didn't operate under 12.5. They sent this notice, and that started a period of negotiation. There's a signed agreement that's an enforceable signed agreement that shouldn't be disregarded, where they said, we'll waive the ROFO right as long as we know you're not getting unfair consideration, you're not involved in the property after the sale. There was 4 years of discovery, multiple depositions all over the place. The lower court looked at this extremely carefully, and Justice Schechter found that that was just speculation, no basis for that. That's why she granted summary judgment.
Thank you. Thank you very much.
I would also point out that I
No,
don't think they
your
made that
time's
argument
up.
below.
Your time's up. Thank you.
Counsel, does the record show any evidence of self-dealing, or is that not an issue?
Oh, there is definitely evidence of self-dealing. The evidence of self-dealing is that, and I'll start with the premise that if all they wanted was to collect $52.5 million for the property, it wouldn't have mattered whether they got it from plaintiff, whether they got it from Meadow, whether they got it from Steele. They insisted it be from Steele, and Maple and Tabak worked to have it Steele because one, Normandy, Maple's affiliate, also had a lease at 888 Broadway that it gave to Netflix. Netflix was not going to lease that property at an above-rate price unless and until Maple committed to give the property to Steele to be leased. And
Can you go back
Tabak
to
had
your
a joint venture. Go ahead.
Go back to your adversary's point that I guess he's arguing before us is 12.5, not so much was triggered, but it was waived based on the subsequent negotiations and with respect to what the representations were going to be with respect to it.
Yeah, I think that each of you have nailed the exact issue, and Mr. Parrott just said we didn't operate under 12.5, and he's absolutely correct, because the way that he's interpreting it, just as your justices acknowledged, is a right of first refusal, and that's not 12.5 doesn't give them cover if they're acting as a right of first refusal. It was a right of first offer, which they did not give to the plaintiff, and they didn't seek to rely upon 12.5. And there's no notice, there's no offer notice that's in conformity with all of the requirements of 12.5.
But does
So
your
what we have is a
client's
waiver.
execution of the waiver of the ROFO obviate any breach on their part of 12.5?
Absolutely not. The only thing the waiver did was waive the right of first offer. It did not waive any breach of fiduciary duty. It does not contain any exculpation of disclaimer of any prior misrepresentation, of which there's plenty.
Isn't your claim that they breached the right of first offer? I mean, your basic claim is that they breached the right of first offer by not giving you the right of first offer. So if you waive that, then you waived, sounds like you waived your claim.
But that's not the claim. There's not a claim that there was a breach of contract and a breach of first offer. The claim here is that there was a breach of fiduciary duty because they went.
Right, but your breach of fiduciary duty assumes that 12.5 is not in play.
That's
But
correct.
if 12.5 was in play, but you waived any breach of it, then what's the claim?
There was not waiving any breach. Each party, both plaintiff and the defendant, Maple member and the appellant, waived their right to exercise a right of first offer because they both had rights of first offer under 12.5. That's all they waived.
Okay, are there any other questions? Okay, thank you very much. We gave you both a lot of extra time.
Thank you.
Forella versus 351 East 61st.
Good afternoon, judges. May it please the court, William Gagas, Dorf Nelson Zouder, on behalf of the defendant appellants. This is a case about physics and science, and the
Counsel,
I thought it was about a fall from a...
I see.
It was about a woman who was drunk and fell from a fire escape.
Well,
Counsel, this is a case about codes and regulations, isn't it? Here you have a requirement, according to the multiple dwelling law, that the treads of every fire escape be 9 inches. Building code says 8, administrative code says 8, National Fire Protection Association says 9, so let's say 8 to 9, and the distance between the top rung descending and the next rung was 20 3/4 inches. And you have someone who fell through that space. So what arguments do you have here? Isn't this about codes and code compliance?
no, Your Honor. It's the defendants move for summary judgment, which is an important procedural context. They've set forth a prima facie defense of the fact that the incident, as alleged under oath by Ms. Forella, the plaintiff, could not physically.
Oh, even though we have testimony from the resident that corroborates what plaintiff says, that your experts, frankly, conclusory statements with respect to physics and et cetera, that this accident couldn't occur the way it happened. She fell through the window, she fell from the east side. It's not sufficient to create an issue of fact?
No, Your Honor. And the photographs don't really do it justice. And with respect to Your Honor's statement that she fell through this opening in the ladder, she said she was standing looking at the building like this, observed the opening to the next lower level on the fire escape, and moved her body backwards, so now she's perpendicular to the building, put her right foot down, and missed the rung. And
there was no rung.
Correct. And where her body undisputably landed, no one disputes this, is 9 feet in the opposite direction, and eastbound, over the edge of this fire escape where she fell on top of a skylight.
Did one of your witnesses say that she had prior experience as a gymnast and probably leaned off something and pushed her body off? And was that really part of the record?
The plaintiff's safety consultants made reference to that, and they don't posit scientific theories. They use catchphrases like air kicks and history of gymnasts and the body doing extraordinary things, not science. And the courts have routinely rejected that. And going back to Romano.
So did Yarmus make some scientific calculations?
He does. He's an expert.
What scientific calculations did Yarmus make?
He calculated the time, the distance, the measurements of this fire escape, and opined that it wasn't physically possible based on the force of gravity. And to understand what they're claiming occurred, based on even their own measurements, is you have a gap of about 6.5 feet between the bottom of the 6th-floor fire escape and up to the top wing, which her body had to, against the force of gravity, continue to be no lower than 6.5 feet while falling, and it's simultaneously moving 9 feet to the east.
Where do the pictures show in terms of, are there pictures on the fire escape of blood? Where is the blood in this case?
Superintendent, Mr. Negron, testified that there was blood on the easternmost side railings of multiple levels of the fire escape on that portion of the building. Again, 9 feet from where the plaintiff entered the stairway or the ladder way. And what Mr. Yarmus finds, and he's an engineer, a scientist, is that this couldn't possibly have happened. And I posit that that has satisfied the appellant's prima facie burden. And in response, we don't have science. We have.
Okay, well, let's assume that you've made out a prima facie.
Sure.
Why isn't the testimony of the resident, let's put aside the testimony of the interested witness here, of the resident sufficient to let this go to the jury? Because you're asking us to find, in essence, that the resident is incredible as a matter of law.
The resident being Mr. Hamlin?
Yes.
Okay. Well, Mr. Hamlin didn't say he observed really anything after he saw her disappear. So I don't think he offered any actual factual evidence of how this incident occurred. And again, the defendants set forth and the case law supports this. If the defense or the claim is based on science, it's supported by science, it needs to be rebutted specifically with scientific evidence in response. And here, we have Mr. Yarmus, but we have plaintiffs, two safety experts who don't even agree how this occurred. Mr. Marletta.
Thank you. You have time to rebuttal.
Thank you.
Good afternoon, Your Honors. Arnold D. Joseph for the plaintiff respondent.
Just clear something up. Did Hamlin testify or corroborate the way plaintiff fell?
Yes, Hamlin testified he saw her go through the hole, okay?
In the fire escape.
Correct. He didn't say, like their expert said, that she went over the railing, because that's what they're saying, that she had to have gone over, not only just the railing, not the railing that went across, this railing. That's the one she had to go across.
The eastern side.
That's correct. And he specifically says she went through, and not only that, this woman who fell the 6 floors, when the police came, you know what she told them? Read the police report. She fell through the fire escape. She didn't say she fell over the railing, okay? Which goes to the whole thing about this intoxication defense, because this woman was still conscious, told the police exactly what happened, had a 15 Glasgow, was alert, orientated, speaking in complete sentences, and after that fall with all those injuries, still asked to call her parents. So the only intoxication part is the blood serum level. That's it. Otherwise, the rest of the evidence in the record shows this woman's not intoxicated to the level that Dr. Brick says that she was.
But going back to really, I think the primary argument is that the accident did not occur the way you're claiming it occurred. So there was blood on the east side, correct, of the fire escape?
Yes.
How do you account for that?
Okay, now, one word was added in, the easternmost railing. That's not what the witness testified to. He testified to the east railing below the window, okay? Meaning the railing that goes, there's no clear whether he meant the railing that's perpendicular or the railing that went across parallel to the building. Because if you look at the photographs, and I urge the court to do this so you see how optical illusions can happen and things can be played with. If you look at the photograph at 1795 and the photograph at 1796, there is a metal railing on the first floor that covers the window shade. If you look at one photograph, it looks like it's adjacent to the very end of the fire escape. But if you look at another photograph, it looks like it's between the opening for the ladder and the easternmost railing.
Counsel, having looked at the photographs, they were very confusing, and for that reason, I wonder if that is a factor that would militate towards having this matter go to trial. What say you?
I say that there are so many questions of fact in this case that if you read this motion, 100%, Judge, I'm in agreement, because the first impression is, hey, I have to discount all the testimony in the case to believe what this expert is saying. That means the resident is lying, that the police report's incorrect, and that somehow this woman managed to understand that she had to say she fell through the scaffold rather than over the railing. And everybody that testified, all the evidence at the accident scene that night is she went through this opening. Now, the other thing that isn't discussed by the expert, this woman is 5'10" tall. She's not 4 feet tall. She is, I'm not gonna say, and she's 170 to 177 pounds. And they say, well, she had to be launched like a cannonball, or she had to be jumping off a diving board. She says, I went to step, there's no step, I fell backwards. Forgetting about the notice, because apparently in this building, every tenant that testified, the two that testified, everybody's been up and down this fire escape, and everybody knows they use it. So this isn't like, oh, it's unforeseeable, and they didn't know people were on this fire escape, and people weren't going up and down. Sure they were. In fact, the only 2 people that testified went up, and even Mr. Bajari said the step that rung was missing before this accident happened when he went up into that same penthouse multiple times. So yes, I agree with you, Justice Gonzalez. There are plenty of questions of fact here that just warrant a trial. And yeah, I think you have my argument. Thank you.
again, it's not the defendant's duty to prove how this accident happened. And that's not what they're attempting to do here. We're disproving how the plaintiff claims it happened because it's not physically possible.
But does that require us then to disregard plaintiff's accident narrative?
Her accident narrative? No, and in fact, I disagree with my adversary that he's saying we have to disregard the testimony. That's what our own expert is relying upon, that she stepped through this opening and, as counsel just said, fell backwards. Everyone agrees. She said she was looking towards the east where she ultimately fell, and if she fell backwards towards the west.
Didn't the testimony say that she was trying to get her foot on a rung?
She was trying to put step her right foot on the rung, and she says then she fell and is not exactly sure what happened after that.
But so would that present an ambiguity then, requiring trial as to where exactly she fell or how she fell?
Not when it's, well, she says this is how she fell, and if taking Mr. Hamlin at his word that she went through the opening, there's still no physical explanation of how it is she went from a position almost 9 feet to the exact opposite end of this fire escape, where her momentum and her body were moving exactly opposite from where she ultimately landed, which is not in dispute. And again, the law is very clear that when the scientific defense is presented, it needs to be rebutted with science. And you have two safety consultants here, not experts or engineers or scientific people. And in fact, they don't agree on what happened amongst themselves. Mr. Marletta, in his affidavit, this is page 2491 of the record at paragraph 92, says it is not likely that the momentum from her fall could have swung and swiveled her body to the front of the platform, where she maintained her grip on the rail, causing her to fall over the front guardrail.
Thank you. Thank you.
If I could just finish one quick point. So he's basically saying she fell from the 5th floor while still holding onto a railing, and the other expert, Mr. DeBose, says she then catapulted down to the 4th floor and somehow fell over. They can't even agree amongst themselves.
Thank you.
It doesn't constitute sufficient evidence in rebuttal. Thank you very much.
West 81st Garage versus Department of Buildings.
Good afternoon, Tahir Sadria, appearing on behalf of the City of New York and the municipal agencies. If I may, I would like to briefly go over the process of how the summons and adjudication process normally works, because I think that this is the source of confusion that resulted in the Supreme Court's decision in this case. Ordinarily, the Department of Buildings inspector issues a notice of violation that's returnable at oath for the imposition of civil penalties in accordance with the penalty ranges of 28-202.1 and the specific penalty set forth in the rules. But the notice of violation also generally contains, and all of the notices of violation here contain, an order to certify correction of the violation. If oath finds that the violation is not established, this order is deemed dismissed. But otherwise, the failure to certify correction constitutes a violation, a separate violation that's subject to additional penalties. Where the notice of violation concerns work without a permit, the party must still obtain a permit and certify correction with the Department of Buildings. And this is where 28-213.1 comes into play. In most cases, when the party goes to obtain a permit and certify correction, the Department of Buildings will impose an additional penalty as required by 28-213.1 before it will issue a permit or certify correction. And this is the exception. The exception is where this notice of violation charges the hanging of an accessory use sign without a permit.
Just so I understand, you're saying that the basic penalty is the basic penalty.
Yes.
This says that if you want to impose additional penalties under this section, you can do so, but an exception is carved out where it's an accessory sign that has to do with the building itself.
That's correct. And
That the court below got it wrong because it took that language to mean all penalties, but it was only referring to the additional penalty.
that is correct.
And that the
And,
court,
and it's in the singular, right? Penalty as opposed to penalties.
Right. It is just the penalty that would be, and it refers, the exception refers to such penalty that would be imposed by 28.
so in this case, you can impose your argument is that you can impose the initial penalty, but you would be prohibited under this provision from imposing additional penalties.
Exactly. That is exactly correct. Just with respect to so that covers this case with respect to the East 84th Street cases. I would just also point out that the determinations were supported by substantial evidence. Hearsay evidence was admissible. The notice of violation affirmed under penalty of perjury constituted a prima facie case. And so there was no issue of fact here that would have necessitated the calling of the hearing of the inspector. So I think the only other little issue that I just wanted to, in case the court was looking, the provision that's related to the changing of copy requiring a new permit, that the code section number has changed and it's now building code section 106.7.2 instead of 105.7.2. So the court has no further questions. The city's position is that all of the administrative determinations should be confirmed.
Thank you very much.
Good afternoon, Jessica Sprague from Goldberg Weprin. For the respondents, may I please the court? Your Honors.
Why don't you first address the issue of the interpretation by the court below of the 28213.1?
I will, Your Honor. Our position is that the exception covers both the base penalty and the correction.
What about the very first beginning of the language, which says, in addition to any penalties otherwise authorized by law pursuant to Article 202 and the rules of the department? Why isn't that referring to the initial penalty? So why doesn't that exclude the initial penalty from the scope of AC 28213.1?
Well, Your Honor, I'd like to go to the legislative intent of Administrative Code 28-213, which is...
Don't we want to first deal with the specific language? Because you first look to the language first of a code or a statute before you look to the legislative history, and if it's unambiguous, that's the end of the inquiry. So what could that language mean other than what Department of Buildings is arguing it means?
And what was the first sentence again, Your Honor?
Argument means. What?
What was the first sentence again?
In addition to any penalties otherwise authorized by law pursuant to Article 2 and the rules of the department.
Well, Your Honor, Article 202, what they're arguing now, was not brought up in the initial oath hearing or the appeal hearing. If you go back to those decisions, they don't discuss Administrative Code 202. They actually discuss a code 1 RCNY 102-02K. That's what oath determined that they're able to get their correction violations under. So them bringing the 202.1 administrative code to light now, we find it prejudicial since it was not at issue at the administrative level during oath.
But they weren't making a determination about additional penalties at that hearing, were they? I mean, there was no attempt by DOB to issue any additional penalties in this case. Wasn't it just a basic penalty that was being decided at these hearings? So why would they even bring this provision up?
It was until we proved our case that there was an exception to the underlying penalties. At that point, they brought up the fact that oath can now impose their own penalties. It was not brought up until the time that the initial oath hearing division decided that we were exempt from the underlying violations.
So it's your position essentially that the city council removed all penalties with respect to illegal accessory signs?
They took away the initial penalties, but again, I mentioned 1 RCNY 102-02K, which the oath decided in its initial decision, that's where they can get their corrective
Well, I'm asking
violations
for
from.
your position. Your position is that you cannot be penalized for an illegal accessory.
Correct.
Now, if city council had intended to do that, wouldn't they have just said that? They would have said that all penalties for illegal accessory signs are vacated or removed, or some language like that?
Well, they do say that all such penalties will be waived from December 2017 going forward. Accessory signs, and these were deemed to be accessory signs during the hearing. Going back to what oath said under 102-02K, which is how they gave their corrective violations, not under Administrative Code 202.1, that says that if OAF were to impose their own penalties, then they can't do so in their own court, in their own house. They have to go before the ECB, the Environmental Control Board, and serve an additional notice of that specific violation of Administrative Code 202.1.
Counsel, the range of penalty, the standard penalty for the DOB violation here is $1,250, right? What is the standard penalty or the range of penalties under 28-213.1, please?
For the corrective penalties, I believe it's $250 a month.
Corrective penalties?
Right.
Not the initial penalty?
The initial penalty was $1,250, which was paid.
Under 28-213.1, are you sure? The department penalty for work without a permit that's referenced there, which says in addition to any penalties otherwise, what is the additional range of penalties?
I believe it's the $250 per month, the corrective violations. So even though the violation was paid and there was no directive by oath of the Department of Buildings to remove the sign, my client is getting corrective violations of $250 per month, presumably that's what they're seeking.
Thank you. You have time on rebuttal.
The penalties under 28-213.1 start at a minimum of $6,000.
That's what I thought.
Yes. The additional penalties of $250 a month, which are not at issue on this record, those are separate, and those are decided under other portions of the administrative code.
And the amount that was fined here was $1,250, right?
Yes, $1,250.
Not $6,000.
That is correct. And there was no discussion
Your
of.
adversary says that a corrective penalty was assessed at $250 per day. Is that accurate?
It's not I believe what she's saying is $250 per month. I don't know. I do know that there is an obligation to.
Is that the amount that was imposed?
The amount that was imposed on this record was $1,250 for each violation.
Not $250.
Not $250.
Not $6,000.
Not $6,000. That is correct. Since then, I don't know that they have corrected the violations, and so there may have been other issues. There may be other penalties based on the failure to correct. But Section 28-202.1 was not discussed because there was no violation of 28-202.1. That is a penalty provision, and that is the general penalty provision, and that the RCNY penalties are authorized pursuant to 202.1. And those are the basic penalties and are not exempted by 28-213.1 exemption. If the court has no further questions, again, I would ask for confirmance of the administrative determinations.
Thank you.
As for the $250 per month, that is under Administrative Code 28-202.1 2, it states for major violations, in addition to a civil penalty, a
Is that
separate,
charged, counsel?
that's under,
No, was that charged? Was that on the summons?
no, it was not.
Was that referenced in any type of decision?
No, it was not, but
So why is that relevant?
because based on counselor's papers, they reference Administrative Code 202.1 and state that is how they can get their additional penalties under oath. It says that that is how oath can seek its penalties. Because, remind you, this is a violation that was brought on by the Department of Buildings, and the court said that the Department of Buildings cannot bring penalties because we were exempt from the violation that was brought by oath. Now, because we are exempt, oath is pushing the position that they are entitled to now bring their own penalties.
About the future?
Excuse me?
Talking about the future?
No, I'm talking about right now, not future penalties. They're saying that they are able to bring their own penalties. So even though we're exempt from the DOB, oath is saying we could still go after you for additional penalties because it does not, the statute does not
So you're
specific.
saying that you're exempt from Building Code 105.7.2 that says that you can't change, can't change the copy of the or make a structural change to a sign without a new permit? You're saying you're exempt from that?
Correct, based on Administrative Code 213-1. It states that accessory signs, which this was deemed to be, and any penalties is waived from December of 2017 onward.
Thank you. People versus Washington?
Good afternoon, Your Honors. Robin Richardson with the Legal Aid Society on behalf of Mr. Washington. I'm here today to ask the court to reduce Mr. Washington's registration requirements to a level 1. I'd like to first address the points assessed under Factor 12, 10 points assessed under Factor 12, which is the acceptance of responsibility.
When did he accept responsibility?
At his 2017 SORA hearing, he accepted responsibility.
How about at the time of sentencing?
At the time of sentencing back in 1989, when he was 17 years old, he did not accept responsibility. It's now been over 30 years since then, and according to the guidelines, the court must examine the offender's most recent credible statement. So as we've touched on, he did make, his most recent statement was at his SORA hearing in 2017. He made a lengthy statement. He said things along the lines of, I quote, "I regret everything I did that day." Another direct quote, "I would never did that again." Now, his credibility should be viewed in light of his disability. He said, "I would never did that again." He was diagnosed within the range of borderline mental retardation. He has particular difficulties with speech, which required him to be in special education classes. And
But going back, did at sentencing, he doesn't take responsibility, and it seems to me that he also sort of plays the blame game. He blames her because there was some sort of arrangement they had with respect to the sale of drugs, et cetera.
Yes, back in 1989, and
But why shouldn't we give that weight?
well, according to the guidelines, the court should be looking to the most recent credible statements. You shouldn't, I mean, you can look to it, but you should also
Well,
look to
recent credible, right?
recent
The question
credible
is
statements.
it credible?
Is it credible? So his credibility should be viewed in light of his disability. His statement was not the most eloquent or organized. However, you could also look to the 30 years where he did not do it again.
But during the 30 years, did he do anything to manifest remorse?
To manifest remorse, we don't have
It's kind of
anything.
late in the game at this point, isn't it? 30 years later, he decides he's sorry.
Well, that's when that's what the purpose of the SOAR hearing is, to look at the defendant there.
Right, what happened during the course of 30 years?
During the course of those 30 years, he never committed another sex offense, and Factor 12 is
He
specifically
did have
concerned.
13 subsequent convictions, including a felony, right?
He did, but Factor 12 is specifically concerned with sex offenses. Under the guidelines, it says the reason why the acceptance of responsibility is so important is because it is critical, since an offender's ability to identify and modify the thoughts and behaviors that are proximal to his sexual misconduct is often a prerequisite to stopping that misconduct. So regarding these 10 points, anything that's not a sex offense isn't really relevant to Factor 12, but those are things that can be looked to. This is a really unique case because most sex offenders are given a sex offender registration level at sentencing or right before they're released from prison, not over 30 years from their release from that sentence.
Counsel, if I may, did the defendant ever offer any apology to the victim?
He did say that he apologized to everyone who was involved.
I see, but
Yeah.
let's go further. Now, I believe that the defendant indicated that he expressed some kind of regret about how this incident affected his life, right?
He does include that in the statement.
All right. But now, was there any recognition on how his actions may have affected the victim at all?
He does not specifically say that. Again, this is a person who is in the borderline mental retardation range.
I just want to go one more step further. Any discussion at all about the victim, his actions, any discussion at all about the victim?
He says he apologizes to everyone involved.
He apologized to the prosecutor, right?
Also to the prosecutor.
Okay.
Thank you.
Good afternoon, Your Honors, and may it please the court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, we respectfully request that you affirm the SOAR Court's order adjudicating the defendant a level 2 risk and assessing 85
How do you
points.
respond to your adversary's point that the most recent credible statement, 2017, is what we should look at, and he accepts responsibility?
Your Honor, the guidelines do state that the court should consider the most recent credible statements, but in the totality of the circumstances. So everything is counted. And so the SOAR Court looked at those statements, and based on the credibility of the defendant, given that he had several inconsistent statements throughout the duration of the case, the judge did not give any value to the defendant's statement.
Wasn't there a key word too here that we haven't used yet, and that's that the expression of, or the acceptance of responsibility has to be genuine?
Yes, Your Honor, that is also correct. And so as Your Honor mentioned, the defendant did not apologize for his conduct. He did not apologize for what he did to the victim. He did not apologize directly to his victim, directly to the victim. He only explained that he's sorry that he never went to the apartment. He's not even sorry that he actually raped her. And so the defendant did not, he also apologized to the district attorney, everyone involved, as Your Honor mentioned, that is technically a very general statement and not a very direct apology, genuine acceptance of apology. And I do want to note that, Your Honors, the defendant did not say any statements at the first SOAR Court hearing that the defense attorney went through the acceptance of responsibility factors and the stranger relationship, and so the defendant declined to say anything at the first SOAR hearing. And it wasn't until the second SOAR hearing where the defendant did, after the judge had mentioned that he's not buying the argument, there needs to be some type of acceptance of responsibility where the defendant says, I did this and I was wrong. And so at that point, the defendant made a statement, and the statement wasn't really a credible, genuine statement, but that is essentially up to the SOAR Court judge to make that determination.
Thank you.
Thank you, Your Honor.
Quickly, I want to address the inconsistent statements that the judge referenced. That was in reference to inconsistent statements made back in the 1980s about what happened at the offense. So again, these are the statements that were made when he was 17. Regarding his lack of making a statement at the first SOAR hearing, that SOAR hearing was never concluded. They stopped because not everybody didn't have all of the information, so they adjourned. And the defendant should not be penalized for not blurting out during the middle of a SOAR hearing. In SOAR hearings, just like sentencing hearings,
Counsel, I'm sorry, because I know your red light's about to go on. What, in your view, is the strongest evidence that your client had genuinely accepted responsibility?
it's his statement in 2017, which he made to the best of his ability.
How can we say, or at least speaking for myself, that it was genuine when it was such sort of a blanket general statement as opposed to specifically addressed to the victim?
Because we're looking at somebody who doesn't have a lot of mental capacity.
Thank you very much.
Thank you.